All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States. Bless this honorable court. Please be seated.
I want to welcome you all here today. We had a reception and a little give and take with the summer interns this morning beforehand out in the courtyard. And I hope everybody has dried out by now so we can proceed. Madam Clerk, since we have 3 cases today, we're going to keep strict time limits on the arguments so that we can comply with the times. And I will tell you for the audience, each side is granted 20 minutes, but the appellant has reserved 5 minutes for closing. So with that, Madam Clerk, will you call the first case?
Case number SC 2023-0603, Sheri Sawyer v. Cooper Tire and Rubber Company. Arguing for the appellant, the Honorable Robert Friedman, and arguing for the appellee, the Honorable William Brooks.
Mr. Friedman.
Mr. Chief Justice, and may it please the court. The complaint in this case includes detailed allegations that Cooper Tire sold, advertised, and ultimately cultivated a market for the CS4 touring tire in Alabama. It alleges at paragraphs 6 and 112 of the complaint that Cooper distributed the tire into Alabama, including in the years before the 2018 crash issue. It alleges at paragraph 7 that Cooper maintained a network of over 300 in-state dealers spread across more than 100 Alabama cities to support those sales. It alleges at paragraph 9 that Cooper tracked the performance of the CS4 in the state by collecting warranty and failure data from Alabama consumers. And it alleges from paragraphs 12 to 13 that Cooper marketed the CS4 to Alabama consumers and also engaged in widespread general brand marketing on top of that. Cooper, in turn, denies almost none of this. It has at no point in this case denied that it distributed the CS4 into Alabama during the years that it manufactured that tire model. It denied for any time period that it marketed the CS4 in Alabama, nor has it denied at all that it tracked warranty information and failure data from Alabama consumers.
Do you have any objection with the facts that Judge Brooks found in his order? Are those accurate? I mean, are there any parts of those facts that you disagree with? Because it sounds like you're saying exactly what he's found in his order. I just want to make sure there's not a discrepancy between the complaints that you filed and what he found. If there are, I'd appreciate maybe some help.
The parties disagree about what one particular fact is, and that's found at page 564. And what Judge Brooks said is tires made by Cooper Tire are distributed nationwide, including in Alabama. And the dispute between the parties, to crystallize it, is what does tires mean? Does tires mean all tires, which is our position and the only one we think is supported by the record? Or does tires mean some tires, such that it's silent on whether the CS4, the particular tire that caused the accident here, was distributed into Alabama? Now, if you accept our interpretation, then yes, the two are consistent. If you accept Cooper's interpretation, and so that it's silent, then they're not consistent. And the trial court was required to accept our allegations as true, because under this court's burden-shifting framework for assessing personal jurisdiction, it is Ms. Sawyer's initial burden to plead jurisdiction, which she accomplished by pleading sales and marketing. But then it moves to Cooper's responsibility to rebut those allegations through competent evidence. And it only rebutted that it shipped tires directly into Alabama for 4 years, and that those 4 years were after manufacture ended. That did not rebut that it was distributing tires before then, nor did it rebut that it was marketing the tire throughout that time period. Now, below, Cooper made that argument because it was relying on this court's plurality decision in Heinrichs. And in fairness to Cooper, Heinrichs did suggest that in a product liability case like this, it's not enough that a manufacturer distributes a product model into the state. It has to first sell the particular product that injured the plaintiff in the state. It's kind of a place of first sale rule. But Ford came down in the middle of this case after Cooper filed its motion.
Now you're talking about Ford v. Montana, the 21 case?
I apologize. The U.S. Supreme Court's decision in Ford versus Montana came down after Cooper filed its motion to dismiss, and it resolved the debate in Heinrichs that was going on between the plurality and the dissent in favor of the dissent. And it laid down a rule that if a manufacturer serves a market for a product model in a state, that's sufficient to create jurisdiction if that product model causes injury in the state, regardless of the place of first sale of the particular product that injured the plaintiff. So that should have been the end of Cooper's motion to dismiss, because Ms. Sawyer had made the allegations Ford says is necessary, sales and marketing, and Cooper hadn't rebutted them. And that also makes
so. Let me ask you this: the time period question. Why did you focus your discovery on 2015 Ford or 2016 Ford instead of the whole time that they might have been distributing and selling this tire?
So I'd make 3 points in response. The first is that we actually just asked for leave to conduct jurisdictional discovery without any time limitation. That was our principal ask. You can find that at page 4.
But your interrogatory was 2016 to 19, right?
Our principal ask was just for leave to start fresh after Ford came down. Our alternative ask was for our previously served discovery requests for Cooper to answer that. And the reason we asked for that time period is because we've litigated, and we know that if we don't put a time limit on, we're going to get an objection that it's overly broad and unduly burdensome. And discovery isn't a one-and-done exercise. So we started with a narrow time period. And if that had come up empty, we would have served additional requests or sought to take depositions. And we were right, after all, that Cooper was still distributing the CS4 during those years, right? It says it still distributed 5,000 tires. It just said that it didn't distribute them directly to Alabama during that time period. So if we were allowed to conduct jurisdictional discovery, we would have then followed up. But the more important point that I want to impress on the court is that that was a discovery request, and it was not any sort of concession or stipulation that those were the years that mattered on the merits for determining personal jurisdiction. And if you look at our briefing below, you'll never once find that we tell the court that those are the years that matter. We started by saying we considered it undisputed that Cooper had sent the CS4 into the state, and then at page 551 of the record, you'll see our proposed order, which obviously the court didn't adopt, but it reflects our position, which is yes, Cooper has now denied that it shipped the CS4 into the state from 2015 to 2018, but that's not a denial that it shipped the CS4 into the state before that point, and that's a sufficient basis to exercise jurisdiction. And now, in this court, Cooper is arguing for the first time, it's making two central points. One is that our allegations were conclusory, and two is that we needed to allege specifically that there were sales before 2015. Now, on the conclusory point, I just note that Cooper never once made that argument below. In fact, at page 213 of the record, you can see that Cooper had clear notice of what we were alleging. It summarized Ms. Sawyer's allegations as Cooper sending the subject tire model, which is the CS4, into Alabama. And as to
so if at some point the facts turn out differently, let's say the facts turn out that they never sold this tire model in Alabama, would they then be able to move for summary judgment on the personal jurisdiction argument?
I think that they could raise that, yes, but we are as confident as we get that the facts aren't going to turn out differently. And I also want to make the point that they cannot, there's an independent basis here, which is marketing. Because in a market like the tire market, that's an independent basis to provide jurisdiction, because it's quite possible that a company markets a tire in a forum state, even if it's not selling directly into it. And I want to be clear that this is not an after-the-fact rationale for us. You look at page 2 of our...
So are you arguing that the Ford decision was broader than the model product that was sold into the state? It would include any product that was sold in the state by Ford?
I should have been clearer. I think an argument could be made, but that's not the argument that I'm making. The argument I'm making is if it marketed the CS4 in particular, even if it didn't sell it directly into the state. And on page 2 of our opposition brief to the initial motion to dismiss, you'll see we raised this argument. We said Cooper marketed it to Alabama consumers not just to get them to purchase it in the state, but also to get them to purchase it out of the state and bring it back. That's at page 241 of the record. And the other argument that Cooper is making to you is that we needed to specifically allege that there were sales before 2015. Now, again, at paragraph 112, we allege that there were sales before 2018, which is the equivalent. And Cooper cites nothing for its new rule that you need to make allegations with such granular specificity. It's contrary to how this court construes complaints in the light most favorable to the plaintiff, construing all reasonable inferences. And it's also contrary to this court's decision in Ex parte Latin, which we cite in both of our briefs, and that rejected essentially the same argument. There, two manufacturers submitted affidavits saying we didn't use the chemical at issue after 2009. This court said that wasn't enough. You also had to submit an affidavit saying before 2009. It's the same thing here. Cooper said we didn't sell after 2015. That's not sufficient. It had to say both that it didn't sell before 2015 and that it didn't market before 2015.
Mr. Friedman, let me ask you, I was looking in preparation for the argument today, I was looking back at Alabama's long arm rule, Rule 4.2b of the Rules of Civil Procedure, and that talks about extending jurisdiction so far as both the federal and state constitutions allow. And I don't recall seeing argument in your briefs about the state constitution. So I'm wondering whether you have an argument about that, and if you don't, I'm wondering whether your argument's deficient.
If it's deficient?
Yes, sir.
It's not. Personal jurisdiction can be waived. So it was Cooper's burden to object to personal jurisdiction under the state constitution if it had a separate argument. If Cooper never said anything about personal jurisdiction at all, this case would proceed, and after a certain amount of time, there would be no argument. It would be deemed waived, and that's what's happened here. There's been no argument raised there. I want to turn to the three facts that the trial court focused on, which were first, that the place of first sale was critical, and that is, again, based on the Heinrichs decision, and Cooper doesn't defend that on appeal, and it's conclusively rejected by the U.S. Supreme Court's decision in Ford. The second is that the trial court focused on this time period, what it called the relevant time period of 2015 to 2018. And Cooper also doesn't defend that legal determination. I think that's because when you're talking about a reasonable expectation that you can be sued in the forum, that reasonable expectation can be created by sales and marketing into the forum in prior years, especially when you're talking about a product like a tire that can be used for a number of years, that can be resold, that can sit on the shelves before it's affixed to a car. And then the third fact that the trial court focused on was Thomas Sawyer's Florida residency. And Cooper admits that this can't be dispositive. And I think so my understanding is that if we're right on sales and marketing, then Cooper concedes that there's personal jurisdiction. But just to clarify.
Help me, though. I mean, the Tyler Ford case that Judge Watkins decided, having a little difficulty trying to distinguish that for you. How would you distinguish that Tyler case? Because that's a residency case, right?
I don't think you need to distinguish it. It's an unpublished federal district court decision, and
he's a smart guy. I'm a big fan of Judge Watkins, but go ahead.
I think he's smart, and I think Judge Brooks is smart, right? But sometimes the courts get it wrong. That's why we're here. And I think that where the court went wrong, and we point this out, is it said, if you ignore the fact that the crash happened in Alabama, then you can see that there's no jurisdiction. You can't ignore that. That's a absolutely critical fact. Because what personal jurisdiction asks about is the relationship between the controversy, the defendant, and the forum. And the controversy, when there's an in-state crash, is in the state. And that provides a really strong foothold for jurisdiction. And when you also have intentional contacts from the defendant, as you do here, sales and marketing, that's all that you need. And if you had a rule that turned on in-state residency, like the Tyler decision suggested was proper, well, first of all, you'd be going against the U.S. Supreme Court's decision in Keaton versus Hustler, where it said in no uncertain terms that the plaintiff's in-state residency is not a prerequisite to jurisdiction. But you'd also get some pretty backwards results. And I ask the court to recall that the driver here, Joseph Coggin, is an Alabama resident. Thankfully, he walked away from the crash uninjured. But had he been injured, he too could have sued Cooper. And then under a rule that turns on residency, what you have happening is Joseph gets to sue Cooper in Alabama. And Miss Sawyer, according to that rule, needs to go to Ohio or Delaware to sue Cooper. Well, if the due process clause of the 14th Amendment has been interpreted to alleviate defendants from unduly burdensome litigation, it doesn't make sense that it would be construed to require Cooper to sit for 2 trials. It doesn't make sense that with one crash caused by one thing, the Cooper tire, as we allege, that there would be 2 trials in 2 different jurisdictions. That doesn't that does not protect Cooper's liberty interest, which is ultimately what we're trying to figure out.
Mr. Friedman, I'm going to switch gears with you real quick. If we were to rule in your favor and reverse the judgment of the trial court, does the Heinrichs decision of this court survive?
I think it depends on how you rule. As we note in our brief, the principal opinion in that case was a plurality decision, so it's not binding. And I don't think that would survive. The decision on rehearing did try to distinguish some other case law based on the fact that GMC, the defendant there, didn't have an in-state network of distributors. If you wanted to distinguish it on that ground, you could potentially keep it alive. But candidly, I think Heinrichs got it wrong. I think the dissent in that case, it's remarkably similar, the dissent to the U.S. Supreme Court's majority opinion in the Ford case. And so I think the best path forward to provide guidance to litigants would not be to try and salvage some piece of Heinrichs, but to just say that the Ford decision is the law. And I see my time has expired.
Yes, thank you, Mr. Freeman. Mr. Brooks?
Thank you, Mr. Chief Justice, Associate Justices, and may it please the Court. This Court has consistently noted that the issue of personal jurisdiction rises or falls on the unique facts of each case, and that rule is particularly applicable here because this case turns on one undisputed fact. There is no evidence in the record before you that Cooper Tire sold or distributed CS4 tires in Alabama. While the plaintiff's complaint did allege generally that Cooper Tire sold CS4 tires in Alabama at paragraph 6, Cooper Tire refuted that allegation. And that fact is what distinguishes this case from Ford, and it is fatal to all of the plaintiff's arguments. The trial court's judgment should be affirmed for 2 reasons. First, the plaintiff did not carry her burden of establishing that Cooper Tire had sufficient suit-related contacts with Alabama to satisfy due process. And second, the trial court did not exceed its discretion with respect to the manner in which it ordered jurisdictional discovery and did not deny any request from plaintiff for jurisdictional discovery that could establish jurisdiction in this case. With respect to personal jurisdiction, this is not a general jurisdiction case. It's specific jurisdiction, and the only issue before you is whether Cooper Tire's suit-related contacts, not general contacts with the state of Alabama, but suit-related contacts, sufficiently relate to the plaintiff's claims to satisfy due process. The standard for specific jurisdiction, of course, is 1, the defendant must engage in activities in the forum such that it purposefully avails itself of the benefits and protections of the forum. The plaintiff's claims must arise out of or relate to those specific suit-related contacts. And third, the exercise of jurisdiction must comport with traditional notions of fair play and substantial justice. This case involves a specific type of tire, a CS4 touring tire that Cooper Tire manufactured. There's no evidence before you that Cooper Tire sold this line of tires in Alabama, distributed this tire in Alabama, or serviced a market for this tire in Alabama.
But Mr. Brooks, they allege that, right? Paragraph 6. Cooper Tire sells its tires, including the subject tire model, to distributors and retailers throughout the state of Alabama. Quote, right? That's what it says.
Yes, sir.
So they've alleged it, right? And our case law says that their allegations govern unless you have disputed them with evidence. And so they don't have to come forward with evidence until you do. And you've only come forward with evidence from 2015 to 2019.
Yes, sir. That's correct. It's our position that Cooper Tire refuted that allegation because, of course, it has no time frame on it. So it can't be construed as time immemorial, that we've got to prove that the tire was never marketed in the state when it hasn't been alleged. And that time frame that you mentioned, Your Honor, was framed by the plaintiff.
How?
After Cooper Tire filed its motion to dismiss, which included an affidavit informing the plaintiff that the manufacture of this tire ceased in 2014, they then propounded their discovery requests that sought information for 2016 through 2019. The trial court actually gave them information on that particular point, the sales of CS4 tires in Alabama, for a larger time period than they asked for. They
didn't have to give you evidence. They don't have to give you. Why should they ask for evidence when you've not refuted their allegation?
Well, it's a matter of the time frame, Your Honor. Over what time period must Cooper Tire refute that allegation? And they complied with the trial court's order with respect to the jurisdictional discovery that was necessary on that point. And there's nothing in the record where the plaintiff told the trial court that time period is inadequate. We need a larger time period for that discovery. We want you to allow us to conduct jurisdictional discovery over a larger period of time. They were silent on that point until post-judgment. And if you compare the discovery requests they propounded post-judgment, which are not at issue here, with the discovery requests they propounded in October of 2020, there's a stark difference between the two with respect to the time period.
But the Aladdin case they cite, which was one of our cases from 3 or 4 years ago, and then it cites the Wegner tree service case, and there's another case. Over and over again, we have said a court must consider as true the allegations of the plaintiff's complaint, not controverted by the defendant's affidavits. So you didn't respond to that in your brief. The allegations are made. You've not given the evidence in affidavits to contradict their allegation, except for the later time period.
Well, it's our position, Your Honor, that we did refute the allegation that we sold this tire in Alabama for what would be the relevant time period as framed by both the plaintiff and by the trial court. It is not disputed that Cooper Tire does other unrelated business in Alabama, or that it advertises generally, things like ESPN, or it sponsors youth safety programs or other things like that, which are merely general contacts. And no matter how extensive they may be, and no matter how extensive they may be alleged, cannot give rise to specific jurisdiction in this case.
So in the Ford case,
yes, sir,
they had Crown Victoria. It's 1994, Crown Victoria.
Yes, sir.
And Ford had stopped making Crown Victorias well before the accident in the Ford case.
Yes, sir.
So how is that different here? You stopped making Cooper tires, the CS4 model, before this accident. You stopped selling them in Alabama before this accident. How do you distinguish that fact from the Ford case?
Well, the Ford case, first, the length of time that they went back to examine the sale of the allegedly defective product was dictated by the nature of the product. It was a specific model year and type car. There was a 96 Ford Explorer in one case and a 94 Crown Victoria in the other case. And the record in that case, as distinguished from the record here, showed what those relevant sales were for that particular vehicle at that time. While the Cooper Tire had ceased manufacturing the CS4 tire, it was still distributing the tire from 2015 through 2018. It simply distributed it to other states and not this state. So I think that the evidence in Ford, of course, is that the Ford sold thousands of the specific product that was alleged to be defective in the forums. There was evidence in the record of that. There is evidence here of no sales. That, we believe, distinguishes Ford from this case.
Mr. Brooks, I think the trouble that I hear Justice Cook maybe trying to make his point of is the allegation of the plaintiffs is for general, like, when did you start? I can't remember when you started manufacturing the tire. Let's say it was 1980 through the date that the complaint was filed. And your response back is from 2015 to 2019. And you're basing that being sufficient on their interrogatory requests. But what I think Justice Cook is saying is that the complaint has a much broader time period, so that made it incumbent upon you to respond back with the greater time period, not just a limited time.
Yes, ma'am.
No matter what the interrogatory said, in order to get past the Aladdin standard and some other things that we have out there regarding the complaint. How would you reconcile those?
Again, we believe that the relevant jurisdictional time period here was framed by both the plaintiff and the trial court, and that after the trial court had expanded the time period that it ordered Cooper Tire to provide sales information, the plaintiff never complained.
The complaint that we're looking at does not have a specified time period, correct?
Correct. It's silent as to that. So again, it was our position that we didn't need to deny that which hadn't been alleged going back to the beginning of time with respect to that tire. We don't know when the subject tire was manufactured, and two, in light of the fact that Cooper Tire was never ordered to produce that information, nor was the plaintiff ever taking the position that that information was relevant. We don't think that it would be proper to hold that the trial court exceeded its discretion with respect to the way that it framed proper jurisdictional discovery in this case. The plaintiff, of course, has taken the position that Ford requires a reversal here. There may be a case that comes before this court with a more fully developed record where the careful analysis of Ford dictates the outcome of that case. This is not that case. Again, in Ford, forum resident plaintiffs sued for in-state injuries suffered due to an allegedly defective product that was purchased in-state. The Supreme Court stressed Ford's extensive contacts that included selling thousands of the same vehicle that was alleged to be defective, and because of those extensive forum contacts in selling the same vehicle, the court held that those contacts were sufficiently related to the plaintiff's claims to satisfy due process. Again, here, the facts are different in the record. There is no evidence before you that Cooper Tire sold or distributed this CS4 tire in Alabama. To get around that fact, the plaintiff has taken a number of different tacks. First, they've alleged that the trial court made a factual finding that Cooper Tire sold CS4 tires in Alabama. That argument is incorrect for two reasons. First, the trial court made no such finding, nor could it. It simply remarked or made the unremarkable observation that Cooper Tire sold tires. It was a part of Cooper Tire's proposed order, and I can assure you that Cooper Tire did not propose that the trial court find that it sold CS4 tires in Alabama. Second, we're here on a de novo review, and the only factual finding from the trial court that would be entitled to any deference would be one made on ora tennis evidence. There was no testimony taken here, so there is no such finding before you.
Mr. Brooks, let me just interrupt you there because we do have an order from a trial judge. It's a very thorough order, and we don't get many of those, quite frankly. So when you get something that's that thorough, what deference do we give that? I mean, it's de novo review. Do we just look at this as, well, it's interesting, but do we give it any deference whatsoever? Is it helpful to us? Or how do we construe this very thorough order by the trial judge if we're on de novo review?
It could be persuasive to you, Your Honor, with respect to the reasoning that the trial court employed, but with respect to being bound by or having to accord deference to factual findings, because we're on a de novo review and because none of those findings are based on ora tennis evidence, they are entitled to no deference. Second, the plaintiff has also attempted to rebuild the record in their briefs through an assortment of references to websites, magazines, and newspapers to fill in the factual gaps in the record. None of that material was before the trial court, and none of it is properly before you now. And in their
And I agree with you, but I keep coming back to allegations. Do you agree with me that we have not adopted Iqbal Twombly here in Alabama?
I do.
And neither party has asked us to do that in this case, right?
Yes, sir.
So we are a notice pleading state.
Correct.
So you didn't move to strike their allegations in their complaint, right?
No, sir.
So they don't, I mean, we're at the pleading stage. You keep talking about evidence until we're past the pleading stage. We don't look at evidence. So to me, I'm still coming back to the allegations in the complaint, and they got the allegations they sold that you sold this tire in Alabama. And then they've got the allegations that you marketed this tire in Alabama. Then they've got the allegations that you have 300 some authorized distributors in Alabama for this tire. I'm just trying to be transparent here. I'm having problems distinguishing this case from Ford if I believe the allegations and the complaint.
Your Honor, the short answer to that is that you can't chop up the elements of Ford into standalone check marks that if you have this, you've got jurisdiction. If you don't have this, you don't have jurisdiction. Merely having dealers in the state does not establish jurisdiction if you're not selling the allegedly defective product. That's what allows the defendant to tailor its conduct to either lessen or avoid what it may perceive as a danger in a particular forum. So if you've got dealers that are selling product A but not selling product B, and the case is based on product B, there's no personal jurisdiction.
There is some dicta possibly in the Ford case where they use the word product instead of model. I agree with you. I think in the O'Scanlan opinion from the Ninth Circuit talks about that question as models that are completely different from each other. But here, they've alleged, again, that you sold this particular model.
Yes, sir, and that goes back to the discussion we had earlier regarding what the time frame for that is. And we believe that we've refuted that allegation through specific affidavit testimony that that product was not sold or distributed in Alabama for the time frame that the trial court ordered. And with respect to the same product rule, the transcript from the Ford oral argument is part of the record in this case. And you'll see in that the plaintiff in that case argued strongly for a same product rule because it would enhance the predictability of the rule and it could be objectively determined. So they very strongly argued for that. And that, I believe, when you read the Ford decision, is what came out of it. Because the court stressed over and over again that Ford had sold the same vehicle that the plaintiffs alleged was defective. With respect to marketing, again, we're trying to separate two things that I believe are intertwined. You're trying to market a product in the state that you don't make available for sale. And as I said at the beginning, there's no case that I'm aware of where the court has found specific jurisdiction over a product manufacturer who has not made available to the residents of the forum the product that's alleged to be defective. So while Cooper Tire does advertise, there's no dispute about that, that's not enough standing alone to subject it to personal jurisdiction in this case.
So if we were to rule against you, you agree you would have a chance at summary judgment to prove that you had not sold CS4 tires through distributors in Alabama.
For a longer period of time?
For a longer period of time.
Yes, sir. Again, the plaintiff also stressed those number of general contacts that I mentioned, things like advertising, sponsorships. Those general contacts, no matter how extensive, no matter how much Cooper Tire may do them in the state of Alabama, do not justify specific jurisdiction. Finally, they mentioned the idea of data collection for warranty and tire failure information from Alabama. That is also a factor that was argued in Ford as being of contact by Ford that was sufficiently related to the claims. You will not find it mentioned in the Ford opinion. It is not sufficiently related to plaintiff's claims here. And if it were, that would stretch the concept of related to its breaking point. And as the Supreme Court cautioned, related to does not mean anything goes. There are, quote, real limits, unquote, to that standard. And while the court did not provide much guidance on what that particular term means, the farther you get away from the sale of the product in terms of a post-sale analysis of collection of data, that does not relate to the particular plaintiff's claims.
Brooks, I want to ask you really the reciprocal question that I asked opposing counsel. You sat down. What's your view on the durability of Heinrichs post-Ford?
I believe, again, I do agree with the other side on that if the opinion is based solely on the fact that the vehicle was sold in Pennsylvania, that does not survive Ford, but that there is an alternative basis on which Heinrichs would remain good law. And the question I've had about it is whether there was sufficient evidence that GM of Canada had purposely availed itself of a particular forum. Because the notion that they had sold a product to a nationwide distributor, standing alone, I don't believe survives under Nicastro. And so if that were the basis for the court's holding, that there was no purposeful availment, I think it's good law. I don't think you have to address it or overrule it in this particular case. Lastly, with respect to jurisdictional discovery, the trial court did not deny any request from the plaintiff for relevant suit-related discovery that would have established jurisdiction. The plaintiff did not seek leave to conduct any specific suit-related discovery until post-judgment. And with respect to the discovery they had requested earlier, as I mentioned, the trial court gave them more than they had asked for. Therefore, I don't think that it would be appropriate to hold that the trial court exceeded its discretion in giving a party more discovery than it requested. In the end, this is not a complicated case. There's no evidence before you that Cooper Tire sold the product that is alleged to be defective in Alabama. And under Ford, that does not satisfy due process. And as I mentioned, the trial court did not exceed its discretion with respect to jurisdictional discovery. For those reasons, we ask that you affirm the trial court's judgment. Thank you.
Thank you, Mr. Brooks. Now, the appellant had reserved 5 minutes for closing. Mr. Friedman?
Thank you, Mr. Chief Justice. I'd like to make 4 points. First, as Justice Cook has observed, we're still at the pleading stage, and we did not need to come forward with evidence unless Cooper rebutted our jurisdictional allegations, which it did not. And we heard a lot just now about there being no time frame in the complaint. As I already explained, that's contrary to how this court construes complaints. It's contrary to Aladdin, but it's also just contrary to the allegations in the complaint. I want to point the court to paragraph 112. Prior to the date of the incident giving rise to this litigation, now me speaking, which was 2018, quoting again, Cooper Tire had manufactured, sold, and distributed automobile tires into commerce in the state of Alabama, having the following specifications. Cooper Tire tubeless radial bearing the name Cooper Tire CS4 Touring P235 65R17.
What was that paragraph again?
112. That is a time frame that they did not respond to. The second point I want to make is, again, we heard that marketing cannot be sufficient or advertising cannot be sufficient. Direct this court's attention to its decision in Ex parte Pope Chevrolet. There you had a Georgia automobile dealer that engaged in what I would call general brand marketing. And again, as I told Justice Cook, we have something more specific here. We have product marketing that we've alleged at paragraph 12. Even in that case, this court found general brand marketing sufficient. The marketing there was, we have low prices for great cars. It was put out in the Atlanta Journal and Constitution, and because that reached Alabama consumers, that was sufficient to create personal jurisdiction. Next point is on Heinrichs. Justice Mitchell, you were asking how to salvage it, and what we just heard was that maybe it's a decision about purposeful availment. I don't think it can be fairly read that way, and that's not the argument that was presented below. As my opposing counsel noted, Cooper was the one that drafted the order that the trial court adopted verbatim, and it relies heavily on Heinrichs, and it does not rely on Heinrichs for anything having to do with purposeful availment. It relies on it for the nexus requirement, the arise out of, relate to requirement. That, I think, fairly read is no longer good law. And that also shows Justice Sellers why, even though Cooper is now saying that's not what we meant by tires, we're looking instead at what Judge Brooks was finding when he adopted those findings. And the best way to interpret that finding, again, this court doesn't need to reach that. It can just go on the allegations in the complaint. But the best way to interpret that finding, in light of the court's acceptance of Cooper's argument about the continuing validity of Heinrichs, is that tires meant all tires. And then the last point I want to make, Justice Cook, you've been asking if they can raise it again in summary judgment. I said yes. In fairness, I didn't give my opposing counsel an opportunity to respond. I just want to make sure I preserve our ability to argue below that they had their chance, and that chance has now passed.
Like I asked Mr. Brooks, we've got this order that's out there, and it makes certain findings, and it can be persuasive, but this is de novo. But this is kind of a complicated case, right? It didn't just start out and you filed a complaint and a motion to dismiss. It went through a number of different hearings, some discovery, briefing schedules, stayed it until Ford could be argued before the Supreme Court, waited for that decision to come out. How do we deal with the other orders that the court issued that may limit time frame or not? Is it de novo review? We just throw all that out. We don't consider that the trial court did some things to try to frame and narrow the case down, or we just get to look at only the complaint and the complaint alone and don't pay any attention to anything that the court did or said about this particular case and how they wanted you to narrow some of these time frames down and other things like that?
So when it comes to the time frame and the merits, this court should review that de novo. That's a legal determination that that's the only relevant time period for the personal jurisdiction inquiry. And this court reviews legal questions de novo. When it comes to the discovery order, now in theory, this court could have reviewed that for abuse of discretion. But the argument that Cooper has raised to defend the discovery limitations isn't that the time limit was a fair exercise of discretion. It's that we never presented a request for discovery and there was no adverse ruling. You can see our request at page 456. The adverse ruling is at 507, and at both 507 and 561 to 562, the court recounts the we presented argument on our jurisdictional discovery request. So overall, to Justice Sellers, to answer your question, I think everything here for you right now is just de novo.
Tell me what relate to means. I don't understand it. I read all the opinions in Ford. What do you think relate to means?
It means having a connection between as I mentioned earlier, the controversy at issue and the defendant's contacts with the forum. And so I think the simplest way to think about it is Ford cultivated this market. It had an expectation that people were going to be using, or in Ford and here Cooper, cultivated this market. It had an expectation that people were going to be using this product in the state, that there would be injuries in the state, that it could be sued in the state. So any in-state injury from that product relates to that market because it has kind of laid the groundwork for people to use that product in the state. That's the relationship between the contacts and the eventual arrival of the product in the state.
Mr. Friedman, your time has expired. We thank you for your arguments. We thank counsel for both sides for your arguments. And with that, we now stand in recess. We'll begin again at 11 o'clock.
All right. The court is adjourned.